everyone, my name is Arvind Panda. I am a fourth year student from UPS Dehradun and currently I am a legal intern in LEXIS and Company for the month of June. And today in this video I am going to talk about the important principle of arbitration law in India. Arbitration dispute is described as an alternative dispute resolution that is often used for the resolution of commercial disputes. Arbitration is different from mediation and conciliation. A mediator or conciliator only suggests the outcome, and it's upon the discretion of the parties whether to accept those or not, whereas arbitration tribunal decisions are binding on the parties. The law of arbitration is primarily based on the law of torts and law of contract. The law of arbitration in India is governed by the Arbitration and Conciliation Act of 1996, which is read with Indian Contract Act of 1872, as we all know. So now let us understand what is arbitration. Arbitration dispute is described as an alternative dispute resolution, and arbitration is a proceeding in which a dispute is resolved by an impartial adjudicator whose decision is final and binding on both the parties. It is way to resolve a dispute outside the court. An arbitration dispute is decided by one or more person which render the arbitration award and is legally binding on both sides and enforceable in the court. Arbitration was first used by Jay Treaty of 1795, which was negotiated by John Jay, and United States and Great Britain had stated that use of arbitration to resolve their issues. Nowadays, many countries use arbitration to solve their dispute. The most important international instrument on arbitration law is the New York Convention. So now let us talk about the general principle of arbitration. So arbitration is consensual. Arbitration is mutual process that requires the consent of both parties. Arbitration is neutral. Arbitration is a neutral process, hence it provides equal opportunity to the parties. Now the another thing is arbitration is a confidential procedure. So arbitration rule specifically protects the confidentiality and privacy of the parties. The next is the party choose the arbitrator. So the arbitrator is decided by the party itself. That's a very important point, important good point of arbitration agreement. So the next is the decision of the arbitral tribunal is final and easy to enforce. Now let us talk about the advantage of arbitration. The first is flexibility. It is a very flexible process and fastest way to solving disputes. Businessmen always prefer to choosing arbitration for solving their disputes rather than any other form of dispute solution. The second is privacy. As we talked earlier, all the proceedings of arbitration are decided according to the choice of both parties. And the third is control. So parties have better control over the dispute resolution process through arbitration. The arbitrators are selected by choice of parties, and also parties can select and specify the legal and procedural rules that will govern the process. The another good advantage of arbitration is party autonomy. So arbitration allow the parties to choose their arbitrator, language tribunal, and even the applicability of law. The next is time. Arbitration consumes less time and is a shorter process than other court proceedings. It saves the time and penal as well as the parties. So now let us talk about the typical step in an arbitration. In arbitration, if the parties was wanted to resolve their dispute, the arbitration process, then the party has to send a notice to the defaulting party to initiate the process of arbitration. So first there happens initial pleading. It is an initial process where the attorneys first meet with their respective clients and discuss the fact of their cases. The second is penal selection. After the statement of claim and answers have been filed, the arbitration tribunal, a list of penal is provided by each arbitrator to decide who will judge their dispute. The next is scheduling. It is an initial pre-hearing conference. The arbitrator and the parties' attorneys have to attend this initial pre-hearing, usually by telephone, or agree on the date of final hearing. The next is discovery. Discovery is the pre-trial phase. This phase was initiated just before the final hearing, due to which the parties attempt to identify and track down all the relevant documents they will need to present their claims to prepare their defenses. Next is final hearing, and then comes arbitral award. The decision given by the arbitration tribunal are known as arbitral award. The arbitration award is binding to both the parties and has been executed by both the parties. So as we by this we all are clear that arbitration is a very good and very time consuming process which parties can adopt. So that's all for today's video. Have a nice day. Thank you so much.